Good day everyone. So today we will tackle the application for provision. So unsa man yung application for provision? So kuan siya, ang meaning is a formal request karang formal request submitted by an individual seeking for provision. So, sa itong provision, ang provision it is a legal status that allows an offender to serve their sentence out of custody or prison or sa jail, typically under certain conditions. So, ang application sa provision na siya process. Okay, so it states here that as provided for in a Parole and Provision Administration Omnibus Rules on Provision Methods and Procedures, application for provision should be filed with the trial court which has jurisdiction over the case that has tried and decided the case of the concerned applicant. So, in simple terms, if someone is applying for provision, they need to submit the request to the court that originally heard and nag-decide bitaw siya sa iyang kaso. Why? Because this ensures that the court with the appropriate authority ang maoy mag-review o mag-consider sa application or sa provision officer. So, naa-jud siya appropriate knowledge or na siya appropriate authority.
Time of filing is mandated in the procedures that the applicant should file the application with the trial court at any time after conviction and sentence, but within the period for perfecting his appeal, which are 15 days as provided by the rules to court. Ang aplikante kuno dapat ang hain bitaw sa aplikasyon for hukuman bitaw siya sa paglitis anytime, pero 15 days sa ang gi-provide nga rules sa court. For the application for the provision should be in the form approved by the Secretary for Justice, recommended by Administrator as any may be prescribed by the Supreme Court. If mag-file ka, dapat ang imong application for the provision is approved sa nimo ihatag sa Secretary or Justice to Supreme Court. Justice to prosecuting officer. The trial court may notify the concerned the prosecuting officer of the filing of the application as a reasonable time to them necessary before the scheduled hearing. So dapat og naay mga file of application i-inform nila before i-schedule ang hearing. So prosecutor interpose to objection basta kay ang application is qualified.
Referral to proper probation office. If the trial court finds that the application is due form and the applicant appears to be qualified for the grant of probation, it shall order the City of Probation and Parole Officer within its jurisdiction to conduct a post-sentence investigation or PSI on the applicant and to submit a post-sentence investigation report or the PSIR within 60 days from the receipt of the order of said court to conduct such investigation. So, ang sabi na dito, no, if the trial court finds that the applicant appears to be qualified or suitable for the grant of probation, si applicant already is the offender. Okay, so if the offender daw is qualified or suitable for the probation, si court or si judge is mag-order sa city or the provincial probation and parole officer within its jurisdiction to conduct a PSI on the applicant. So, first of all, what is PSI? So, masabtan na to in an easy way. PSI or post-sentence investigation refers to the investigation conducted by a probation officer to obtain information regarding petitioner's characters, antecedents, environment, mental and physical conditions with the aim of determining whether the latter is qualified and suitable for a release under probation. So, that is PSI. So, sabi daw, ang PSI is like, if ang probation officer, trabaho ni siya sa probation officer. So, kung kinsa may duty na probation officer, si probation officer need siya mag-conduct og investigation to obtain such information regarding to the petitioner characters or the mental and physical condition, kung si petitioner ba ay possible maging qualified or disqualified, or cause of isa iya mental and physical condition, of course with the aim of determining kung suitable ba or qualified na si applicant grantahan og probation. Pero in case the PPO or the parole and probation office task in conducting PSI cannot submit the PSIR within 60 days due to reasonable circumstances, si probation or si probation office is pwede siya i-extend. Mag-file lang ka o kani motion of extension of time to submit PSIR. Di kaning PSIR is diri masulod ang mga findings sa probation officer kung magrantahan ba or ma-deny ang petitioner. So within 60 days daw dapat maka-issue na si probation officer, maka-issue na siya PSI kay judge. Hindi daw or makulang siya adlaw, hindi siya ma-extend. Mag-apply lang siya or mag-file siya rather o motion of extension of time to submit PSIR. Okay, next, the docket book. The Parole and Probation Office should take note that all copies of course ordered for post-sentence investigation it received shall be numbered consecutively and recorded in the docket book. So it's stated here that the Parole and Probation Officer dapat mag-take notes. Na si PPO daw dapat all na makopya sa court order or the PSI na dapat daw siya numbered consecutively and recorded in the docket book. This is for the purpose of indicating therein, among others, the date of receipt, the court, the branch and address, applicant's name, criminal case number, description and designation of the offense, penalty imposed, and the other related data information. Like, in the docket book, there is a docket book is like of the information of the applicant or the post-sentence investigation, diri nakasulat sa docket book. The old is like the mark the background of the applicant. Okay, then Next, effects of filing, I mean filing and receipt rather. Effects of filing and receipt. Based on the rule, the trial court may, upon receipt of the application filed, suspend execution of the sentence imposed in the judgment. So, there is a effects of filing. So, makafile na o kuan na doon probation. Depende. Ito effects though, so possibly pwede na ma-suspend ang sentence ng petitioner upon filing the petition.
Okay, so now, dirita sa post-sentence investigation. So, post-sentence investigation or PSI, no person shall be placed under probation except upon prior investigation by the probation officer and a determination by the court that the end of justice and the best interest of the public as well as that of the defendant will be served thereby. So, unsa man gyud yung PSI? So, nag-refer ng PSI or post-sentence investigation to a thorough examination conducted by the Parole and Provision Officer or PPO. Kung baga, background check bitan siya done by the PPO or after someone is convicted. So, PSI helps the court decide if the person can be granted provision by looking down their background, circumstances, and potential rehabilitation. On adere, post-sentence investigation is the vehicle used to find out the petitioner's legal qualifications and his suitability for provision. So, ang PSI dahil is a process. Process na siya ha. Then, kaning process is very integral to ensure that ma-ensure ang fair and informed decision regarding sa pag-grant or pag-deny sa provision. Kay lagi ang goal sa PSI is to make fair decisions about whether ang provision is suitable option ba instead of jail. Okay, now so dirita sa investigation of court referral. So, PPA or Parole and Provision Administration is tasked to undertake PSI by means of referral coming from the court. So, ang Parole and Provision Administration under sa Department of Justice mao ang mag-conduct sa PSI or the post-sentence investigation based on court referrals. So, ang goal ani is to provide courts of essential information and thoughtful recommendation for selecting offenders na eligible for provision, which exclude those entitled to specific benefits under relevant laws. So, all offenders except those entitled to the benefits under the provisions of Presidential Decree Number 603 and similar laws are covered as beneficiaries of PSI. So, unsa maning PD number 603? So, Presidential Decree Number 603 kay is also known as the Child and Youth Welfare Code. So, all offenders DI are covered as beneficiaries of PSI except atong entitled nga naka-benefit under DI sa PD number 603 known as the Child and Youth Welfare Code o sa similar po ng mga codes ani. Okay, so during sa investigations, si Parole and Provision Officer kay mabusisi na i-examine ang criminal record, family history, educational background, marital life, occupational background, and ang interpersonal relationship ni provision applicant or petitioner. Kaning comprehensive review or pa-examine nag-aim to assess the suitability for provision. So, to gather more information, officers check local police files, karang court records, NBI, or etc. in some cases, ang mga petitioner kay i-undergo sila og drug dependency test or psychological evaluation to better understand or to assess ang potential nila for rehabilitation. Okay, so now let's talk about amicus curiae. So amicus curiae, it is a Latin phrase which literally means friend of the court. So naadiri amicus curiae refers to someone who assessed the court. So when we say friend of the court, kung ano siya, individuals or entities invited to a court to provide assistance or information on legal matter. Even though di sila directly involved sa kaso, karang kuan sila dili involved sa case, but they assess the court by offering insights, expertise, or opinions na might be relevant to the issue at hand. So provision officer in their respective capacities act as friend of the court. Kinsa man ni sila ang mga mo-appear na amicus curiae or friend of the court. So pwede si administration or deputy administrators sa agency level. Si regional director para sa regional level. Tapos si chief provision and parole officer or sa city or sa provincial level. So again, amicus curiae in the context of provision is ano siya, ila i-share ilang knowledge on provision practices and related issues, like ilang valuable perspective without being considered as expert witnesses, helping the court to make informed and fair decisions.